Good evening, afternoon, or morning, everyone, depending on which time zone you are in. My name's Alex Schwartz. I'm Deputy Director of HKU's Center for Comparative and Public Law, and it is my great pleasure to be chairing this book talk today with the authors of How Constitutional Rights Matter, a new book from Oxford University Press by Professors Adam Chilton of the University of Chicago and Professor Mila Versteeg, the University of Virginia. Those of you who are interested in comparative constitutional law, and particularly empirical comparative constitutional law, will probably be familiar with their work. They've been publishing around this area for several years with some very notable publications that are connected and tied into this particular book. This book, however, expands on that work and connects the quantitative evidence with some great qualitative case studies. I have to say I'm a fan of the book. I think it's beautifully written, it's elegant, the theory is compelling, and the evidence is persuasive. So that's my short review. I will let the authors begin now with Professor Versteeg, if you would like to begin to tell us a little bit about the book. That will be followed by Professor Chilton, and then we will have some opportunity for questions and answers with the authors. Thank you very much. I'll let you go ahead.
Great, thank you. First of all, thank you so much for having us here, Alex, and everybody at HKU, and hosting this talk, and for people for attending, taking the time to listen to us. We hope to share our insights, but also to learn from you as well. So feel free to ask us anything you want to ask us. So the basic question we're trying to answer in this book is not an easy question to answer, which is basically, do constitutional rights actually make a difference? And if so, how? And looking around the world, it's, some like to believe that constitution, once you write a right in a constitution, it will magically work. But looking around the world, there are some cause for skepticism. So we sometimes start our inquiry with three basic trends that we wanted to show you just to motivate the question. So first of all, as constitutions are being rewritten, there tends to be a lot of emphasis on the rights provisions in the Constitution. International community tends to be heavily involved, tends to encourage countries to adopt rights. And indeed, one notable trend is that over time, we've seen that constitutions contain more and more rights on average. So this little graph shows the average number of rights that countries have in their constitution. And by 1946, this was about 21 rights. By 2012, it was about 42 rights on average. So the number of rights on average has doubled. So countries are becoming more and more protective of constitutional rights, at least on paper. At the same time, we actually also, over the past few decades, seen an improvement in actual human rights practices. I know at this particular moment, it may not always feel that way because we're talking a lot about democratic erosion and democratic decline around the world. But overall, if we take a slightly longer perspective, in the last 6 decades or so, we have seen rights improve. And the data here that we show on the second graph is data from a political scientist, Chris Ferris, which is widely used, and it sort of purports to capture government repression and torture, and higher scores means better rights practices. So that's the second trend we have. We have more rights on paper, we have more rights, better rights protection in practice. But then third, quite puzzling perhaps, is that the correlation between those two is actually negative, meaning that countries that have more rights in their constitution actually tend to do worse in practice often. So this is a bit of a puzzle, right? It gives one pause, like, what does that really mean for saying something about whether constitutional rights seem to be matter, meaning are associated with better rights outcomes. So we asked this question, are rights really more than just parchment barriers, as James Madison, one of the drafters of the US Constitution famously put it. And we can also give you some examples from around the world that sort of, illustrate that this question there is no obvious answer to this question. So I don't know if anyone recognizes this provision, but it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right to people to peacefully to assemble and to petition the government for a redress of grievances. This is the United States Constitution. Sounds really nice, right? And you may have seen this provision. The US Constitution is fairly well known around the world. But here we have another provision from a different constitution, which reads as follows: citizens are guaranteed freedom of speech, of the press, of assembly, demonstration, and association. Citizens are entitled to submit complaints and petitions. Sounds similar, except it's not Canada and it's not France. The country that has this provision is actually North Korea. So there is that. And then we can find other examples. So there shall be no discrimination on the basis of sex in Pakistan. It doesn't take you a lot of research to find out that there is a lot of discrimination on the basis of sex in Pakistan. Nobody may be subject to physical or psychological torture in Zimbabwe. I actually worked for a human rights organization in South Africa, and we try to document evidence of torture in Zimbabwe. I can assure you it does happen in Zimbabwe with some frequency. And then education is the right of all citizens of Afghanistan, which shall be offered free of charge up to the BA level. Afghanistan is actually the country with the lowest literacy rate in the world. So it's easy to find examples where rights are not upheld at all, right? So what do? We are trying to answer this question empirically. And it's a really hard question to answer. And Adam will, in a few minutes, say more about how we go about doing this and how we take up this challenge. Because this question really has motivated scholars to debate constitutional rights effectiveness ever. I mean, in the US, the debate goes back to the founding. James Madison said, oh, rights will be merely parchment barriers. Thomas Jefferson, another founder of the US Constitution, thought they did matter. And ever since, scholars have made a lot of claims about this, but nobody's really trying to test this empirically. So that's our goal. I can just, as a preview, I can tell you we're using a range of different methods to get at this. We're using statistical analysis, we're using case studies, we're using surveys, survey experiments, we're using expert interviews, and so on. But Adam will say more about that. I will just, before we go into the methodological debate and talk about our methods and our findings, I just want to give you an overview of our core claims that we make on the book. So after having done 7 years of research, we were just saying we started this book project in 2013. It wasn't a book project then, it was just a single paper, but one paper became 2 papers, and at some point we had like 6 or 7 papers, and then we turned it into a book, and here we are 7 years later, it's finally published. But based on all that research, we developed basically 3 basic claims that I wanted to give you up front before we go in sort of the more nitty-gritty of the methods. So the first claim that we're making is really the starting point is rights, well, don't typically do much is one way of putting it, or in any case, just putting a right in the Constitution in and of itself is not necessarily a guarantee. I said, my slides say 4 claims, by the way, I really meant 3. In any case, that just putting a right in the Constitution is not in and of itself a guarantee that the right will be upheld. It's around the world, as my examples just show, it's relatively easy for governments to violate rights, and it happens often. And we start with the book with this sort of theoretical problem that we think is inherent in constitutional law, but also in administrative law, international law, many different areas of public law, which is that this is a body of law that purports to constrain the state, but at the same time, the state is also the main enforcer of this same body of law, right? So rights in constitutions tell governments that they can't do certain things, but who is ultimately going to tell the government that it can't violate rights when it wants to do so, right? So let's just, if we compare this with ordinary private law, let's say the law of contracts, if me and Alex have a contract and Alex violates the contract, I can go to court. And the court is, it's an external court is part of the state. It's not me or Alex that gets to ultimately decide who wins the claim. No, there is this external body, a court, and the enforcement apparatus by the state to enforce the contract. But the contract between the citizens and its government, there is no such obvious enforcement mechanism, right? There is no external court or international army or something like that that come and enforce the social contract between the citizen and their government. So that's the problem. There is no external enforcement mechanism, which makes rights enforcement difficult. And one thing we say in this in this article is that in the book, is that it's not obvious that courts are a solution to this problem. We talk quite a bit about courts, although, you know, fleshing out what courts really do is complicated. But just like a government can ignore the Constitution and its rights provisions, it can also ignore courts. And we see many examples of this. One of our case studies, we document the rise of the Law and Justice Party in Poland, which is a right-wing populist party, and was able to basically undermine a lot of the Constitution's rights protections. And one of the things it started to do was just ignoring courts. Well, it didn't really exactly say that. It's more complicated, but at some point it stopped publishing the decisions by the Constitutional Tribunal, right? So it's hard. There is no external enforcement mechanism for the Constitution, but also not for courts. Courts are ultimately, or can ultimately, be controlled by the government, right? So that's our starting point for the book and for our theory that we use to motivate the inquiry, this theoretical problem of having no external enforcement mechanism. That doesn't mean that rights cannot be enforced at all. They can, but some things need to happen for this to be the case, right? And some people say, well, sometimes it's just in the government's interest to enforce rights. Okay, fine, that's easy. But why would governments respect rights provisions when it is not in their interest to do so? And here we say it needs to be politically costly for governments to violate the Constitution. Somehow there need to be political consequences if you ignore the Constitution and its text, or if you ignore court decisions enforcing the Constitution. There needs to be a political consequences for that. And we say that citizens can make this happen. So citizens, ordinary citizens, or the other party to the contract, right, the people, if you want, they can protest, they can engage in acts of civil disobedience. Sometimes they can litigate, they can try to not vote or mobilize against rights abusing government in the next election, right? So citizens can do certain things that make it politically costly when a government ignores the Constitution. And the idea is that the Constitution can help those citizens enforcing their rights if they want to. So the idea is that people can take the streets and wave the Constitution at the government and say, hey, now you have crossed the line, right? That's sort of the basic idea for why constitutions maybe or rights may be protected. And other people have argued this before, that enforcement actions by private citizens are really quite important. However, we say, okay, yes, this is great. Citizens need to enforce the Constitution, and this may make it costly for government to ignore it, and that could be the answer to our problem. But we also say there's two different problems for citizens who want to do so. There is a coordination problem and a collective action problem, and let me explain each of those. So a coordination problem. So first, citizens need to actually agree with each other that there is indeed a violation, right? So in theory, it's easy to say, oh, it's clear that the government has violated the Constitution because rights are written into the Constitution. But we as lawyers know that rights are by themselves often not very clear, right? So for example, if the Constitution bans free speech, does that mean that the government cannot place any viewpoint restrictions on speech at all? Or can it maybe place certain viewpoint restrictions? Or what if, as some leaders have done, the government just starts buying or intimidating the media? Is that a constitutional violation? Actually, it's not all that clear based on the text of the Constitution itself, right? So first we need to agree that there is actually a violation, and sometimes this is hard, especially when government officials go around saying, no, we're merely upholding the law, this is not a violation, and then there is dispute over whether or not the Constitution is violated, and that creates problems for this kind of enforcement action. Second, there is a collective action problem in that citizens actually need to orchestrate their actions. They need to come together and say, okay, this is what we're going to do to make it costly for the government. So maybe we need to organize a protest. Maybe we need to organize multiple protests. Maybe we need to go to court. Maybe we need to mobilize against certain candidates in the election. But that's not obvious, right? Disconnected citizens need a strategy. And here we make the claim that what's really important is for citizens to be organized somehow. We need organizations dedicated to rights protection to help citizens do this, right? To help citizens agree that, okay, certain actions actually cross the line and warrant this kind of enforcement action. And then second, we're gonna take the streets and actually do something about it, right? Or so organizations can come up with that strategy that we need. So as or just put it in the language that I just used before, organizations can help overcome both the coordination problems and the collective action problems that are inherent in rights enforcement by private citizens. Here we make another move building on sort of literature and recent insights, and I'd love to get people's perspective here on that here in light of sort of the enforcement actions you've seen in Hong Kong. But our claim is that maybe what we really need is formal organizations. So there is some very interesting research in sociology that shows that social media movements are not always as effective as they could be, because they keep having disagreements over, what is the strategy we're really going to follow, because nobody's in charge, right? There's no formal organizational structure. So there is this sociologist that did this case study of the Gezi Park protest in Turkey, and argues that if these were not done through social media, then maybe they would have been more effective, because this was a dispute that started when President Erdogan started removing ancient trees from Gezi Park, and that spurred protests around the country that were really about the increasingly authoritarian nature of Turkey. But Erdogan was very smart and said, okay, no, I'm keeping the trees, so you don't have to protest anymore. And then there was disagreement among the social media activists, because it wasn't clear what exactly the strategy was, what exactly the movement was about, what they really wanted to accomplish. So it was an effective strategy for Erdogan to dispel the movement. So let me sum up where we are, right? We need citizens to enforce rights, but rights enforcement by citizen is not easy, so we need formal organizations to help citizens agree that when there is rights violations and actions are needed, and as well as to coordinate what actions are needed. So this takes us to a second core claim in our book, which is some rights come with organizations, right? So I just told you this whole story of we need formal organizations and citizens disagreeing with the government, but it's worth noting that some rights have a built-in organizational structure. They come with organizations because you need organizations to practice those rights. So examples here, we have 3 examples that we really explore in the book, although there could be others, are the freedom of religion. So freedom of religion, the right to unionize, and the right to form political parties. So the freedom of religion, you could theoretically exercise your religion alone, but in practice, people need churches, religious organizations to practice their religious rights, right? So you can't, nobody really wants to practice their religion alone. So freedom of religion, there are religious groups. These are not established for the purpose of protecting rights. But when their rights are being violated, they are perfectly well equipped because they're already organized, they already have leaders, and they have all the incentives to push back against rights encroachment by the government. The same is true for the right to unionize. You can't really exercise the right to unionize without trade unions. You do need trade unions. So trade unions are not established to protect constitutional rights. No, they're established to get better wages and working hours for their members. But if governments push initiative to undermine workers' rights, the trade unions are there and they can use the Constitution and they can try to improve their own rights situation in that way. So we say that you know, the fact that some rights have these natural constituencies and are practiced within organizations may make a difference. We're not saying that it's impossible for other types of rights to have these kind of organizations, but it's harder, right? So free speech, take the example of free speech. You don't really need a free speech organization to practice, to exercise your opinion. I mean, it's a little complicated, and we talk about, like, is the press this type of organization? And we ultimately conclude it isn't, and we can say more about that in the Q&A about why the press is different ultimately from freedom of religion. But these rights, the freedom of expression is much more of an individual right. The same is true for the prohibition of torture, right? The prohibition of torture, there's no usually anti-torture organizations, or they may be there, but they're not necessary to practice the prohibition of torture. It doesn't even make much sense to say that. So we say there's two different types of rights. Some rights are organizational in character. They have these natural constituencies and organizations, and other rights are more individual in character, and they do not. So that's the freedom of expression, the prohibition of torture, free movement. We also look at the right to healthcare and the right to education, which are really social rights in that they entitle citizens to certain goods, but they're also ultimately individual rights, we say. So we make this distinction between these different types of rights. And we will show, and Adam will talk about this in a second, that these rights, these organizational rights, we do actually find that they matter, but for the individual rights, it is much more difficult to enforce them, and likely only happens in some countries under some circumstances, but we do not find any compelling evidence that they work everywhere. And then the third claim we make is that governments dedicated to rights repression will often eventually succeed anyway. So our story is like these certain rights can slow the government down, or they can, you know, rights enforcement can happen for certain rights, but ultimately rights are never a guarantee. So one thing we observe is that when governments are truly committed to violating the Constitution, they often get their way in the end. So we say, well, we love to tell ourselves this story, and I'm sure you've heard this if you have taken a class in constitutional law or constitutional theory, that constitutions are the ropes that tie us to the mast so we can resist the singing of the sirens, right? This is Homer's Odyssey, that the constitutions are to nations what to Ulysses, who wanted to sail by the coast of the Sirens without jumping in the water and losing his mind, right? He asked his crew to tie him to the mast so he could hear the singing of the sirens and not drown like all the other sailors did, right? So there is this analogy, like the famous analogy, constitutions are the ropes that tie us to the mast so we don't, like many sailors, go nuts when we hear the singing of the sirens. So they prevent us really, truly from doing certain things. And we say, oh, that analogy doesn't really work that well. What we really think that rights are about is they are speed bumps. They can slow the government down when it wants to repress rights. And there's the things that citizens, organized citizens can do. But ultimately, in many cases, government play a long game. So we end on this note that is not so optimistic, which is that, you know, ultimately, I mean, we can talk about whether this is ultimately really depressing, or maybe it's still good that we can slow the government down because it allows us to fight another day, and maybe they'll be out of office by that time. But that's the third claim we make. I said almost on my slides, I said 4 claims. We're not sure. We have maybe 3.5 claims, because we have a claim about courts, which is that courts ultimately don't make as much of a difference here, right? So legal scholars and lawyers like to think, well, if we can litigate and if courts can enforce the Constitution, that helps. And we say, well, that's not all that obvious, because courts can just as easily be ignored as the Constitution itself. And we believe that what really matters is these organizations. But we ultimately also want to be careful about what we say about courts, because we know sometimes courts can help social movements and organizations that want to protect rights. Sometimes they can hurt these groups when the government basically controls the court. So the story about this court is complicated. So we don't ultimately come down one way or the other on courts, I think, in the book. In earlier versions we did, and then we toned it down a little in any case. So I think these three claims we're basically settled on. Okay, and with that, I want to turn it over to Adam.
All right, I'm trying to figure out, Mila.
Oh, I should stop my share, right?
Right, how to.
So I think you should just share your screen now.
All right, everyone, thanks for having us here. When you stopped sharing slides, Zoom disappeared from me.
There should be Adam, there should be a green icon down in the sort of bottom center of your screen that allows you to share when you see it.
Yes.
Yes, great.
All right. This now worked? Let me just
yeah,
that's all there. We can see it. Yeah.
Perfect. All right. Everyone, so as Mila laid out, what we've tried to do in our book is think through the conditions under which adding a right to a constitution concretely improves the protection of that specific right. So if the country decides that we're going to prohibit torture, does that then translate into less torture going forward? Or if the country decides that they're going to include the right to education within their constitution, does that mean that they somehow improve their educational outcomes, whether or not it's spending more money on education, improving test scores, literacy rates, school enrollment, etc.? So does the act of writing this constitution and putting rights in that constitution concretely change the way that rights worked? Now, Mila laid out our basic arguments that in general, putting a right into a constitution doesn't change much. It may be the case, however, that for rights that create organizations that are then able to enforce those rights, that for those organizations, like religious groups, unions, or political parties, putting a right in the Constitution matters. But over the long haul, even that might not be enough. Now, we've got these specific question and specific claims. The question is how we can go about making some progress on that. Now, as Mila gave the example of James Madison, the architect of the US Constitution, being skeptical that rights may do very much and saying that they were just parchment barriers that wouldn't really stop the government. Now, this view that he held made him initially skeptical to put rights into constitutions, but he eventually changed his view for essentially pragmatic purposes. He thought it would make the Constitution easier to pass. Now, that same basic story played out again as it did in the United States in the 1700s, in the 20th century after World War II, only in this case, it wasn't the United States that was having this debate, it was former British colonies. And so as of 1959, the British Empire includes a range of countries that are have colonial relationships still with the United Kingdom. And the United Kingdom was in a process of decolonization, of helping or allowing, whatever it may be, these countries to gain their own independence. And at the time, constitutions were being written for these countries. Now, a great deal of the constitutional drafting for the former British colonies was done at the so-called at the Lancaster House, a specific property owned by the Foreign Service in the UK. And these constitutions, as a result, reflected the views of the British government, not necessarily local conditions. So you had legal scholars, experts, diplomats, etc. from the UK, along with some number of representatives from the countries drafting these constitutions. And the result was a fairly standardized constitution called the Lancaster House Constitution that ended up being put into place in a number of different countries. Now, importantly for our purposes, before 1960, the view of the Lancaster House and the Foreign Service was that Bill of Rights don't do very much. They're parchment barriers, as James Madison said. And as a result, they're not important and worth including. Now, after 1960, that view switched, but the reason that it switched is essentially the Foreign Service became convinced that it would make it easier to get public buy-in for constitutions if they included rights, because the public would be happy in these newly independent countries if they were to be given specific rights. So what you have is this change in whether or not countries that have British colonial histories have rights in their constitution that happens as a consequence of the change in thinking within the Foreign Service. In other words, whether or not Ghana or Nigeria or Kenya or Tanzania gets a Bill of Rights isn't anything specific about that country as much as just facts about the views of the Foreign Service at the time that they get their constitutions. So as empirical researchers, we thought that this presents a great natural experiment to see whether or not countries that end up with a Bill of Rights do better at protecting rights than countries that don't. So here's the basic data. Mila mentioned the human rights score at the start of the presentation, which is a measure of human rights protections. That's sort of an aggregate measure of the protection of human rights in a country. 0 is average, positive numbers mean 1 standard deviation better or 2 standard deviations better, negative means worse. Here's the country's average human rights scores over time as they got a Bill of Rights. What you see is that they're roughly average of countries in the world in 1960, and they slowly get better over time. Now, here's the countries that got their Bill of Rights before 1960, excuse me, their constitutions before 1960, former British colonies, and as a result, did not get a Bill of Rights in their constitution. What you see is the exact same basic trend line. They've increased almost the exact same amount, but they did it from a lower starting base. So it doesn't necessarily look like the Bill of Rights meaningfully changed the trajectory of countries at all. Then in both cases, human rights have improved slowly over the 20th century, and which is roughly the story around the world, on average, some countries aside. Now, this is important for us, though, because even in this situation, there's so many nice properties of this experiment for an empirical researcher that you have many countries that have had some common shared experience. That is, that they were British colonies, but they're in different parts of the world. They're in Africa, they're in the Caribbean, they're in Southeast Asia, etc. So you have regional variation, size variation, but this exogenous shock and a Bill of Rights. This should be a great natural experiment to answer our question. But even this, with this information, which suggests that maybe the Bill of Rights didn't do very much, it's not enough to concretely answer the question or make all of the arguments we want to, for a few reasons. One, the fact that there's such a different initial starting place before 1960 in these countries and their human rights records tells you that these two groups were not the same. This wasn't some perfectly randomized experiment. And it turns out the countries that got independence faster were countries where human rights was worse. And so as a result, these aren't really the same treatment and control groups, so to speak, of who got a constitution and who didn't. On top of that, we don't have great human rights data until countries gain their own independence. So at that point is when essentially the data starts getting collected. So as a result, we can only look at this graph starting in 1959 or 1960, but not going all the way back till, let's say, 1930 to give us a really great before and after. And on top of that, this is looking at all of a Bill of Rights as a yes or no package. But our theory is that some rights matters and others don't. So it doesn't necessarily prove our whole theory, just that not rights in itself doesn't do enough. So where does this leave us? What this is hopefully should illustrate is even if you go out and spend time in the historical record to find the closest natural experiments to having rights versus not having rights, that alone won't be a good enough research design to concretely answer the question that we're looking at. And instead, we have this problem that at the end of the day, the adoption of constitutional rights is just this deeply endogenous process. And what I mean by that is that it's nothing like a lab experiment where there's some master constitutional planner that gets to go around and say, you have the right to education randomly, and you have the right to freedom of speech randomly, et cetera, to create the conditions where we could sort of study this like a new vaccine trial, right? Where we've got treatment and control groups that allow us to really measure the effect of these rights. And instead, some countries have rights because they have groups in that country that really care about it and that argue forcefully for that right. Other times, countries have constitutional rights because they're copying some regional leader or human rights treaty. But whatever the reason, it's not random. And in addition to not being random, countries often change their constitution at a time that they're changing in other ways, right? They're newly independent, or they care more about democratization, or they're caring less about democratization. Whatever it is, the addition of rights often coincides with profound social changes, right? So a country is just radically changing at the same time it gets a new constitution. So if things are different in the 10 years after this new constitution on educational outcomes or health outcomes, or there's less torture, it could be that the new constitutional right is what made the difference. Or it could be any of those other massive shocks to the country that all happened at the same moment. The way to think of this is, even if we could find the right set of countries to look at something like a treatment and control group, something like a vaccine trial, it would be like what we were doing is shooting into people at the same time 15 different vaccines, and then at the end asking ourselves, did one of those vaccines make a difference? We'd have no idea. And by that I mean, countries don't just add the right to education, they add the right to education and set up a presidential electoral system at the same time. So all of this taken together just makes it extremely difficult to answer this question. And the result is there's a number of prominent legal scholars that look at comparative law in some contexts that have said we should just give up on these kinds of questions. So Holger Spalman's a friend who teaches at Harvard Law School, who does empirical comparative law. And he said trying to answer these kinds of questions with causal claims and statistical methods is likely to do more harm than good because of these kinds of problems that I just said. Jonathan Click, who teaches at the University of Pennsylvania Law School, has said that studies can be close to worthless in having confidence in causality when they're making these kinds of cross-national comparisons. Now, those views are reasonable in that the conditions are not perfect for any one study of these questions. There's going to be problems with it. But the approach that we've taken is sort of summed up by a political scientist at the Massachusetts Institute of Technology, MIT, Rich Nielsen, where his argument is that when we're talking about comparative politics, when we're talking about comparative law, all of the interesting questions are hard to answer. This property that I'm talking about, and we're talking about in our book about the effectiveness of rights, the same thing could be said about the effect of laws generally, or what government to set up, etc. And at the end of the day, countries are going to make choices about how to design their constitution. They're going to pick a presidential versus a parliamentary system. They're going to pick how to structure their courts, lifetime tenure or shorter tenures. They're going to decide whether or not to have a right to education. And when making those choices, they can either do it based off no evidence at all and just the arguments that people make from first principles, or we can at least try to get in the data and, while being cautious, say the best that we can. So we've accepted that all interesting questions in public law are hard to answer and decided that the right approach is that instead of trying to focus on any one method, is to try to use a variety of mixed methods to triangulate on the answer. And if you can find the same thing in different settings at different times with different methods, that should give us some more confidence. Now, to be granted, this is a bit of a folk theory of causal inference. There's no statistical proof that we can concretely say beyond the shadow of a doubt. But we do think that by showing many methods that all produce the same result, that should give us some confidence in our theory, and that's a better approach than to just giving up, walking away, and saying, let's go to small questions where the variance, the causal inference, is easier to do. So what exactly do we do? And I'll try to go quickly here. So first is that we try to improve the data that we have available to study these things. Now, that's happened in a few ways, of which Mila should just get massive credit, because this is all her, which is the first complete coding of rights within constitutions. So Mila took every one of the 194 major recognized countries in the world, found their constitutions, then found every change to those constitutions, and documented all of the rights within those constitutions, including all of the variants of those rights. And so we can say with confidence—
legislation projects, it was like a decade ago, but still.
Right. Yeah. This is how Mila spent her dissertation writing as a graduate student, is reading every constitution in the world. But what you can see is that on the graph in the left, for instance, Mila showed you at the start of the presentation that the average country has doubled the number of rights in their constitution. But this is a trend that goes basically across the board. So that's decile of countries, that essentially everyone's been adding more rights over time. Now, to complement this, we're aware that there are some so-called small c constitutional rights, rights that don't show up in written constitutions. And to supplement the coding of constitutions, we conducted an expert survey with 200 experts from 130 countries around the world to document the small c constitutional rights in their country. That is, the rights that aren't written down in the formal document. And as a result, being able to learn more about what rights countries actually recognize. So even if we can't show you the causal impact of those rights, we can say more than ever before about what the rights around the world actually are. Next, we tried to leverage these natural experiments like I talked about when possible. They're not easy to find. There's only so many instances in the world of countries sort of having this random constitutional shock. We've got the Lancaster House constitutions. Additionally, one thing we've been researching is Japan's post-war constitution sort of randomly included a right to gender because one woman in the room was able to add it. And so that's a sort of random shock to Japan. And there we see that there's no change in their trajectory of women's rights after doing so, which is consistent with our broader theory. Now, from these natural experiments, we try to move on to just general large N analysis. That is, we use cross-comparison data using a range of different regression techniques to try to all get at this question about does the protection of the right improve after adding the right? Now, we use a variety of techniques, but one thing we really focus on is the event study approaches, where we look at before and after a right is added to a constitution, so we can at least say within one specific country, do you improve after you add this right to your constitution? And what we can say is, on average, for individual rights and for social rights, there's no change in the trajectory after adding a right to their constitution. The right gets added, but nothing really changes after. Now, one reason that that might be true is that, that people don't really care about many rights or if they're violated, which goes to what Mila was saying earlier in our theory, that you need an organization to make people care, to help turn out people to protest. And so we tried to do survey experiments around the world. We've now done survey experiments in Turkey, the United States, Japan, Taiwan, Israel, a range of countries, trying to see if people are told about current problems going on, if learning that that particular problem is a constitutional violation, if it does anything to change public opinion. So it's just one example on this. Within Turkey, Turkey banned the website Wikipedia within its borders. This seems to be a pretty clear-cut violation of Turkey's constitution and their right to freedom of expression based on the writing of their constitution. However, Erdogan is extremely popular when he did this. And so we conducted a survey that was done through face-to-face interviews across the entire country of Turkey with a nationally representative population, and basically told them about what was going on with Wikipedia. And for some people, they were randomly given information on the constitutional facts and tried to see if this changed their view on what was happening in the view on this ban. And essentially, it didn't change people's views at all to know that what was happening was unconstitutional. And instead, if they supported Erdogan, they were okay with this happening, even if it was unconstitutional. Which shows you that just the fact that something's unconstitutional alone doesn't necessarily change the political leader's calculus, which again is sort of consistent with our broader theory when we're not able to find sort of quick changes to public opinion in surveys around the world now on different topics. Now, finally, I'll say one last thing, which is a lot of what this book was trying to do was try to marry those other forms of research, case studies, survey experiments, natural experiments, large N research with case studies. And by that, what we did is went to different countries in different regions in the world, into Tunisia, Colombia, Russia, Myanmar, Poland, where there's been problems going on, constitutional crises related to these rights. And we've tried to understand the role that the Constitution actually played in those disputes. And in our case studies on unions in Tunisia or religious freedom in Russia or political parties in Myanmar, the Constitution really does help the groups that are organized and gets them the ability to fight back against the government. But in cases like Poland, or for freedom of speech, or Colombia for the right to healthcare, individuals are on their own, so to speak, and the Constitution has played a much smaller role in these constitutional disputes, which again, not dispositive, but is sort of consistent with the broader arguments that Mila tried to lay out. All right, I think we're over our time, so I'll stop taking there and hand it back over.
Thank you very much, Adam, and thank you, Mila, for that. I think as the audience haven't bought the book already, I would encourage you to, because I think, as you can see, it combines both a intuitive, compelling theory, which is elegant, with a great mix or combination of methods to triangulate to get at this thorny problem of causal inference, as Adam was just explaining. So there are lots of interesting ideas there to discuss. I'm going to open the floor to the audience here through the Q&A function. So what that means is that I've chaired one of these before, so I now feel like a veteran using the Zoom Q&A system. So you can type your question in the Q&A box, it'll appear, and I will then sort of collect them and then pose them to our panelists. But to kick things off, I wanted to start with just two questions, one about your own reactions to the research and another about the reactions of others. So with respect to your own reactions, so this theory is, the way it's explained is lovely and elegant and intuitive. And so I wondered actually if there was anything that you discovered here that you nevertheless found surprising in this research. So because when one reads the first part of the book, you're sort of carried along by the argument and you think of, well, of course this has to be right. Organizations matter. Lonely individuals are going to be bad at enforcing their rights. And it chimes well with other things that we've seen in the literature before, the EP book, and also the Rosenberg Hollow Hope book, both of which talk about how courts and rights may not be enough unless they're supported by other factors. So I think it's consistent with that, and intuitive in the way the theory is explained. So was there anything sort of surprising or shocking to you as you came along this, and came through the research? And the other question was about how this has been received. We were talking at the outset about how lawyers and legal scholars like to think that rights are powerful and that courts are consequential. So, I mean, what do you think are the claims here that have sparked the most pushback or controversy amongst the legal academy when you've been presenting this to different audiences? So those are two questions, and I'll start collecting questions from our audience as well.
Go ahead, Adam.
Yeah, sure. I'll say one thing on both of those questions. And the first, what was surprising? So for me, the finding that's the most surprising, and one that we're still trying to explore more before staying more forcefully, is the effect of whether or not countries are democratic versus autocratic, which is essentially, we found that individual rights don't really matter much in democracies or autocracies, and organizations seem to matter in both. In other words, whether or not a country is autocratic or democratic doesn't really matter for the effectiveness of the rights. Now, to be clear, democracies do dramatically better at protecting rights than autocracies. It's just whether or not it's in the Constitution doesn't seem to make a big difference. So you have, for instance, countries like Australia or New Zealand that have, pretty good records on human rights. I don't know, some issues with migrants aside, or other topics, but in general are pretty good, but they don't really have these things written down. On the other hand, you have autocratic countries like North Korea that have everything written down and do a bad job. So our claim is not that democracies and autocracies are good, but in both cases, the adding the right doesn't really change their trajectory, which was inconsistent with some prior research. For instance, Beth Simmons, who's been the sort of leader of studying human rights treaties, her theory is all about how democratic a country is what matters in the effect there. So that's the surprising thing. The reaction, the piece for me that's gotten the strongest reaction is one of the first parts of this was we have a paper that we looked just at torture, and we named the paper "The Failure of Constitutional Torture Prohibitions." And when I presented that, I had about 3 incidences at different conferences and workshops where I was sort of publicly yelled at. And I think part of what it was is that, I don't know, I think since I teach at the University of Chicago, that people thought I was like saying some sort of like John Yoo style, George W. Bush position, that it was okay to torture. When the whole reason we're studying this is that we think torture is bad and would wish we could reduce it. But when we said that the constitutional torture prohibitions don't work, a lot of people push back and say they're important, that we have to have them, that torture is horrific, etc. And so people, I think, at times have had difficulty separating the descriptive claims we're making from normative claims about the importance of the values. I'll stop there.
Just to add on that, so I teach at the University of Virginia, so people don't necessarily, that's Thomas Jefferson's university, so they don't necessarily assume I oppose rights. Maybe it's also because I'm nicer than Adam. No, I'm joking. But in any case, I think, like, in terms of the question of responses, I'm always surprised how some people take this as a really optimistic message about rights, because we do have some good news in the book, right? Like, if you can organize, you can actually protect constitutional rights. And we tell success stories from around the world of this happening, like religious groups in Russia actually able to push back President Putin's initiative, right? Which is kind of surprising, but it shows that even in an authoritarian context, this can work. And then other people taking this as a bad news story. So I think you can, because ultimately we see leaders often succeed, and we see that some rights don't matter as much. So I feel like this is like with much empirical research, you can take it as a glass half empty or a glass half full. And I think that's also how you can look at our findings, I guess. In terms of what was most surprising, I think I was most surprised by the 3rd claim we end up making, that ultimately, the leaders find a way to get around the Constitution if they really want to violate certain rights. And that's something we see, and they're so savvy about it, right? Like we see these strategies like buying the media or trying to co-opt certain groups. I mean, the list goes on, right? How sort of using maneuvers rooted within law, they ultimately undermining the Constitution anyway, if they can play a long game. So I think the 3rd claim I hadn't really prepared for, but it's something that I think we saw in our case studies over and over again in particular. I think the 3rd claim really ultimately comes more from our case studies, right? Like ultimately these groups win these battles, or they win these great battles, and we're so happy, and then they lose in the long term. So that's I guess something I didn't really expect that we were gonna say, but that we ended up saying anyway.
Thank you, Mila. I now have 2 questions from the audience here that I can pose to you. I'll just take them together. Larry Spears asks, what do you think is the best argument against your conclusions that rights matter to the surprisingly little, I suppose, as expressed in your book? So that's one question. I guess maybe that's pointing to, like, where do you feel the doubt is in your own thinking about the claims of the book? Sung-Chun Lee asks, can you elaborate more on the 3rd claim, governments dedicated to repression are likely to eventually succeed? Supposing, this goes back to what Mila was just saying, supposing that citizens are empowered by organizations, are governments still able to succeed eventually? What are your recommendations to those who are faced in these situations? So interesting to kind of draw out the practical kind of implications of that problem. So I'll let you respond to those questions.
Mila, how would it work if you take the second of these questions and I take the first? All right, so I'll take the first question. So what's the best argument against our conclusion that rights matter a little is expressed in the book? So here's the thing that I find most persuasive or am most concerned by, or is the most troubling for us, which is, I think we can all think of examples where rights were important, at least people in comparative law. And so, for instance, if you are from the United States or familiar with the United States political system, our Constitution, our Second Amendment here, has the right to bear arms. And it's been, I think, massively important in continuing gun rights. And so it just it feels not plausible to Americans to say the Second Amendment hasn't mattered for our ability to police guns. Another example that I'll admit to being no expert about this country, but that is been used quite a lot, is the right to healthcare within Brazil. And so roughly 1988 or something, Brazil adds a right to universal healthcare. And the statistics in Brazil on life expectancy, infant mortality, a range of different measures got better pretty noticeably pretty fast. And it's a sort of a big success story for this. And there's of course other examples that people will point to and say this right in this country's done great and that right in this other country. Now, we don't deny that there are instances of this, you know, I believe those stories, and there's plenty of other anecdotes. Our claim is that on average, that doesn't happen. So in some countries, things might get better, in other countries, things might get worse, but that on average, there isn't a clear pattern. But what's possible that what's happening is that there's just scope conditions. And so, you know, the right to bear arms matters if it's in the Constitution and you have the federalist system and some other fact about the world. And we just don't know what those facts are yet. And so we might be saying rights don't matter when really it's rights matter if you have A, B, and C, and we just don't know B and C yet. And so that's the concern that I have, given that there clearly are instances where things get better after individual or socioeconomic rights, which we are sort of skeptical of after they've been added to constitutions. All right, Mila, do you want to try the third question here?
Yeah, like how to save constitutional rights in the long run. So first of all, let me say, I wish I actually knew the answer to the question, because then, you know, I would give way more talks than I'm currently giving. But I do have some thoughts, right? So one way to, like, so we, just a very simplified version of our case study in Russia. So in Russia, we studied religious freedoms, and we show that religious groups are actually able to push back against the Russian government that wanted to increase control over all religious of all forms on a number of occasions. And to a very simplified version of the story was 3 times did the Russian government try to push a major legislative initiative that would have severely curtailed the rights of religious groups to practice their religion in public, to be able to recruit members, and so on. And they were mainly worried about smaller foreign religious groups, the Jehovah's Witnesses, the Scientologists, all those that were not the Russian Orthodox Church, but the laws were written in general terms. So there was 3 major initiatives, and twice groups were able to stop it. And the first initiative, I believe, was like in the late 90s. It took about there were in total like 2 decades apart, right? These different initiatives. And twice the religious groups were able to stop this from happening because, first of all, they protested very strongly in all sorts of different ways, including acts of civil disobedience, mobilizing international alliances, pushing against, you know, lobbying politicians, and so on. They were also litigating to the extent they could based on, but that was not as much based on stopping these initiatives. In any case, twice they succeeded. The 3rd time they failed. What happened the 3rd time around? So first of all, the Putin government basically first negotiated with the Russian Orthodox Church. So the Russian Orthodox Church was no longer opposed, it was now on board. It said, okay, we were able to carve out sufficient number of exceptions to those laws that we think we're fine, we're gonna run with this. So then it was suddenly those small groups by themselves trying to protest, right? So the broad alliance fell apart, which really shows that sometimes it really helps to have a broad alliance. And then second, the other thing that changes, they use these procedural irregularities, which we often see when these laws get passed again and again. So one thing that we've seen in a number of our case studies, government passes blatant law, there's a major outcry in the country, people are upset, like then they're like, okay, let's not do this. 5 years later, they're doing it again, but they're not as obvious and blatant about it, right? So it sounds a little bit more neutral, although they're kind of doing the same thing. And then they may use these like private member bills. So this is a bill that is introduced by a member of parliament instead of the government, or they are using some procedural routes that are like introducing changes between the first and the second reading that are not marked up, and then they're holding a session late at night, and the opposition was just not paying attention. Right? So we see these sort of procedural moves that are not necessarily illegal, but they're using basically trying to minimize publicity for what's happening. And so often we see, and we've seen the same in Poland and other places, that on second or third or fourth attempt they succeed because maybe the opposition got tired, maybe the alliance broke apart, maybe they weren't paying attention. It's hard, and it's harder to get like the country to be really upset when the government is less blatant about it, right? So some of these things may change over time. Governments become more savvy about it, and then so what's my advice? Keep paying attention, I guess, keep working on building broad alliances, try to mobilize, even if it doesn't seem as outrageous as it seemed the first time around, even though it still is, but they're just more nuanced about it. I mean, but I think that's hard for many groups, and make sure that no part of the alliance is being co-opted by the government, which is also what happens. Okay.
Thank you, Mila. We have another question, which I think kind of continues in the same vein, but I wanted to sort of interject a point here about the scope conditions for, I suppose if you were to pitch this book as advice to people who are interested in drafting a constitution, one read of it might be, well, don't worry too much about rights content unless it concerns these organizational rights, because they're the ones that really matter. But as you note in the book, there are other reasons why it might be good to include rights in a constitution, which are not tied so closely to the idea that they will have practical consequences. So I guess I would just want to kind of make sure that people aren't taking away the message here that we should think about rights purely in these kind of instrumental terms. There are other sort of symbolic and important purposes that they serve in terms of brokering a constitutional settlement. They might be important for that. So even if we don't really understand them as consequential necessarily, there might be other reasons. And also the scope conditions, because we don't, as the book says, because we don't really understand the scope conditions so well about when they might be consequential, it would be sort of bad advice to say to constitutional drafters, well, don't include this because it won't matter, because actually it might matter because the scope conditions might be right in that particular context. So I think that the book does a good job of presenting its case in a nuanced way. So I just wanted to make sure that others here in the audience who maybe haven't read the book don't come away with taking the wrong message away from it. That it certainly isn't meant to be advice not to include rights in constitutions because they don't matter. I will say, though, that I guess, in my own experience in Northern Ireland, having worked there and written about the context there was a debate that went from the time of the Good Friday Agreement on over a decade afterwards, and to some extent is still sort of alive, about the creation of a Bill of Rights for Northern Ireland. And one of the controversial sticking points there was the inclusion of socioeconomic rights. And so there was a group of interests within Northern Ireland who were quite fixated on that part of it. And I think probably this book would be good for people in those contexts to read, to get a sense of that they shouldn't hang so many hopes on de jure rights provisions, that you're not going to transform or just your society or destroy neoliberalism because you include socioeconomic rights in a Bill of Rights. So I think I would just chime in with that point. So that leads me to the question that someone in the audience has asked. Should we advocate universal rights protection regardless of the effectiveness of constitutional rights, given that there are these gaps in our empirical knowledge? This is, I guess, maybe your opportunity to speak on behalf of the universality of human rights, if you want to. That the door is open to speak in those terms, if you like.
Well, so let me say something both in response to the question and in response to your comment. So I think Adam and I probably agree, but I, in any case, strongly feel like constitutional law professors should generally try to stay away from giving advice to other countries' constitutional adoptions of anything. I mean, I think this was, you know, the 1990s was this moment where it was the end of history, right? We all had agreed on this one remaining model of how to govern countries, and we had this sort of illusion that we knew what a good constitution looked like. And many famous constitutional law professors from the US, Germany, other places, they would go around. I mean, this was this moment of unprecedented constitution making. Would go fly around and tell countries, oh, you need to do a US style presidential system because look what a great democracy the US is, right? They were, no, really, you need the German system. And they were proud of doing so. They were writing law review articles, talking about how they drafted the constitutions of other countries. And I think, you know, some 2 or 3 decades later, we've become a whole lot more modest about what we know and do not know about constitutional design. I mean, part of like what Adam and I would say is like, we never actually had any real data. These were just law professors just pushing their own normative beliefs on countries, and it often failed spectacularly. But even if you've done all the work that we've done, we still want anyone to be cautious, right? Because part of the constitution, I mean, and this is something we don't really get at in the book, so I'm just like conjecturing here, but for people to mobilize against rights violations, the Constitution itself needs to have some legitimacy, right? They need to think they care about the document, or certain groups need to have at least some faith that this document matters. So if it's written by, I don't know, law professors from the University of Chicago, certainly may not be the case, right? So I think we just want to be careful with the whole constitutional design debate anyway, I think. And so if countries want to adopt rights, they should be adopting rights, because as we also point out, there's a whole lot of other reasons for doing so. It may help improve legitimacy of the document. It may change the way politicians talk politics, right? I think that's something we don't really get at, but some sociological studies have shown, right? Rights are a discourse in which we state our claims. May not change rights protection, but it changes something, and maybe that matters in the long run in some way we can't measure, right? So there's all these reasons that we don't really get at in the book, I guess, for why you may want to adopt these rights anyway. Adam, I don't know if you want to add anything.
Yeah, sure. You know, there were a number of prominent theories, let's say 20 years ago, that having more rights might actually make things worse. So Ona Hathaway, who teaches at Yale Law School, argued this in a couple of articles. And the basic mechanism was to say, if you're a dictator or an autocrat or a bad government of any kind, and you say, we're not going to torture now, that people might get off your case a little bit. And by doing so, getting off your case, you might actually get to torture a little more or something. And so the claim was that maybe things are worse by adopting these rights. They don't make anyone better, but they distract the West or the Washington consensus or whatever just enough so that you can, the governments can oppress. A variant of that argument that my colleague Eric Posner made was what he calls the hypertrophy of rights, where he says that like protecting rights is expensive, and each right you add to your constitution makes it more difficult to do everything. We can't do it all. There's just not enough money, time, resources, etc. So you might start off saying we'll protect education, and then you add healthcare, social security, housing, rights to various affirmative rights of different kinds. And when the government can't meet them, then people think, oh, the fact that it's a right doesn't matter because the government is going to not meet it anyway. And by doing that, he thinks that you like each additional right makes it less likely you'll protect the first right. So there's been variants of these arguments that have been advanced. They may be true. I've never seen clear empirical evidence for either one, that more rights make things worse. Again, it could, but we've never found that. Instead, we find a lot of some rights where there's positive effects, these organizational rights, and other rights where it just doesn't seem to move the needle. Now, what's important of that, though, is this gets to the initial question and comment, that I don't think that we say then don't add rights to your constitution. And if there's moral reasons, political reasons, practical reasons that countries would want to have a right to recognize what they think is important as a national value, to recognize a moral debt that the government should respect, to broker a political compromise, we don't have any evidence to suggest that countries shouldn't do that. And that in fact, it might be extremely normatively important to do that. The only thing that we would say is exactly like the Northern Ireland example, which is, it would be a shame if activists, lawyers, scholars were spending their entire career only focused on a mechanism that wasn't a particularly important mechanism. And so really what we hope is that we can continue to work to find what will move the needle and what that may be. And it might be the right set of institutions, the right set of veto points, whatever it may be. But rights alone are not going to likely to be enough on average, I think.
Thank you, Adam. I have one more question, if I can, if you'll allow me, from our director, Professor Pojan Yap. Actually, speaking of veto points, so Pojan asked, does the endurance of rights simply hinge on the veto points in that political system and the party who bears the burdens of legislative inertia? So I will leave it to both of you to answer that question as you like.
Yeah. Can I ask a clarification? What do you mean by endurance of rights, like the staying in the Constitution or being respected?
Let's see. If
the
Pojan...
enforcement or the fact it's staying, so both.
Okay, because first of all, on endurance of rights, one of the interesting things is rights always get put in the Constitution. They never ever get taken out, right? If you look at sort of the data, it's really not popular to take rights out of a Constitution.
Sorry, what I mean is when it's judicially operationalized.
Okay, so the endurance of, yeah, I was just saying the one exception is the right to bear arms that most countries were able to remove from their constitution, except for the United States of America that still strongly protects us the right to bear arms. But veto points in the political process, I mean, Adam, do you have a response or?
Yeah, so yeah, I was gonna jump in with an example that we actually conclude the book with, which is, in the United States, there were, I'm going to get the number wrong, but let's say roughly 100 constitutions that were written for Native American tribes, for the so-called Indian tribal constitutions. And these constitutions, whether or not the administration in power was a Democratic president or a Republican president, some were set up as presidential systems and some were set up as parliamentary systems. And that is that they were sort of more unified executive control or more broad-based control, more veto points. And it appears the more veto points, the more broad-based control, 100 years later, 150 years later, it's worked much better. You know, of course, there's still many problems on many Indian tribal reservations, but on average, the countries that got more broad-based control have enjoyed better economic success, better protection of rights, more inclusive government systems. And I think what this suggests is a lot of what's important is figuring out the right government structure within the Constitution. The difficulty is we just often don't know what that looks like ex ante. And so, for instance, people will talk about the importance of setting up independent courts, and they can point to you courts that are independent. But it's a little more difficult to know what you would say at the time you were writing the Constitution, what creates that court. Is it life tenure versus fixed terms? Is it being appointed by the legislature versus the executive? What it is exactly that does that. And we only sort of know an independent court when we see it, not what predicting it when it's written in advance. So what this means is I think that finding veto players is important. It's just tough to know what you write down to make sure that there are those veto players that behave as you would predict. All right, I'll stop there, Mila.
Yeah, no, and I think it's not something we really explore directly in the book, but it's worth pointing at this. There's an article by a political scientist called Jonathan Lupu, and he says in the context, he finds some evidence that in the context of human rights treaties, more veto players within the political process does improve rights protection. It's just not something, like, it's actually interesting. One of the things when we started this project, there was this huge literature on human rights, the impact of human rights treaties. So do human rights treaties actually make a difference in the same way we've been looking at, do constitutional rights make any difference? This literature is just started in the early 2000s, whereas we're like 2 decades behind here. So they've taken up a lot of subsequent questions, right? They started with the inquiries like ours, like on average, does this matter? And since then there's been like 60, 70 papers. I may be exaggerated, but in any case, a lot of papers, and some of those have gotten to the question of veto players. I just don't think we've fully gotten there yet, other than some conjectures in our concluding chapter.
Excellent. Well, thank you very much, Adam and Mila, for joining us today to talk about this excellent book. And I would encourage everyone in attendance to pick up a copy, because it really is a remarkable book, and I think a very important one. And thank you both, I should say, also for the time zone, because you've joined us at sort of an awkward time for talks. We have people coming in from all over the world as well at different times. So my thanks to you as well for joining in wherever you are. And so, yes, please do pick up the book. And thank you, Professor Chilton and Professor Verstig, for joining us today to talk about it.
Thank you so much, Alex, for hosting this, and we'll see each other. Bye.
Yes, we'll see you. Bye-bye.